guys for coming today. We're super excited to be able to have this discussion. And for those of you who we know, welcome. And for those of you who we don't yet know, we are excited to get to know you better in this time period. I'm Samantha Buckingham, and I'm the director of the Juvenile Justice Clinic at Loyola. I also have the great delight of, at this moment in time, teaching criminal procedure over the summer. It's an interesting time. And also, I'll let Professor Kennedy introduce himself.
Hi, I'm Sean, and I'm the executive director of the Center for Juvenile Law and Policy. Sam and I work a lot together defending at-risk youth in delinquency court. We're thrilled to be having this discussion. And right now I'm teaching trial ad on Zoom this summer, which is pretty relevant, I think, to our discussion today, because I haven't been able to get any live hearings for a long time now. Sam, I don't know about you.
I have a live trial scheduled, and it's a little bit scary. I think all of the options above are scary, to do it remotely or to do it live. Each pose different challenges and risks. All right, Maya, next slide. Great. We wanted to get an idea of who is here today, and so there's a participant poll to try and figure out if you guys are actually practicing attorneys in criminal law right now. Are you defenders, prosecutors? Are you working with adults? Are you working with kids? We're going to talk both about criminal justice and juvenile justice. So it looks like we've got mostly people who are actually not practicing in criminal law, so you're interested in what is going on, and I thank you for that interest, even if you're not actually practicing in criminal law today, because this is a really huge issue affecting all of us in our society, and I thank you for being engaged and caring about what's happening. And it sounds like, of those of you who are working in criminal justice, we've got a bunch of defenders, a few prosecutors, a bunch of people working with adults, and a few people who are working with kids. So thank you guys for participating in that poll, and it's great to know who's in the session. Maya, next slide. So we're going to talk a little bit about what's happening with kids in the juvenile justice system and about adults in the criminal justice system. So pre-COVID, our statistics for any given day about who is detained in the juvenile system were about 500 kids detained in juvenile halls pre-trial, and about 500 kids detained in camps and other locked facilities where they were after their juvenile disposition, which is basically like a sentence, right? So juvenile hall is the equivalent of adult jail, where you are waiting pre-trial to have your case resolved, and then the camps and other locked facilities are where you would go after you've been sentenced. Professor Kennedy, what are the latest stats that you have tracked down for us about this population of kids who are detained?
Yeah, for those who don't know, probation now puts out what they call the daily COVID-19 update. It's actually every couple days. It's a pretty good resource. The most recent one says that there are 355 kids in juvenile hall and 202 in camp, for a total of 557. And they say that right now 10 kids have tested positive for COVID, all in juvenile halls.
Great. And do you want to talk at all about how that compares to the adult system at this point, or you want to talk about that a little later?
No, I think that this is a good time. So Sheriff Villanueva has been doing this quite a bit longer. The Sheriff Department was a little ahead of the game than probation on disclosing COVID stats. And he says that right now they have 172, the total population of the adult detention is 12,105 as of today. They say that 172 adults have tested positive, 235 are isolated. I think that means that they are experiencing symptoms and don't have test results yet. and they have 5,197 adults in quarantine. So it looks like a much bigger, uh, uh, I guess, universe of people who are suspected or may be suspected of having COVID in the adult population. But I also think that's because the sheriff's department has been testing earlier and more.
And I saw we had a question that came up in the chat asking back to the juvenile statistics. Of those 557 kids who are detained currently somewhere by the probation department, what are how many of them have been tested? I mean, I think that's something that I don't have a clear answer on. I know that what they're doing now when kids come in to the juvenile hall is that they are testing them now, but they're not necessarily testing everybody who's already been in juvenile hall or been in juvenile hall this entire time period. So they're only now have they just begun to screen kids with tests when they come in and hold them in quarantine when they first come in to the juvenile hall.
That's right. They've started to test incoming for a long time. They did not test anyone who was asymptomatic, even though we know that asymptomatic people can carry the virus. So I don't know that we have a handle on that. They are testing everyone now who comes in.
Yes, exactly. So Maya, if you could move us on to the next slide, that'd be great. Thank you. So for those of us who are working with kids in the juvenile justice system and operating as their defense attorneys, our number one goal is to advocate for the release of our clients from detention. You know, there's a lot of problems that we're going to continue to talk about throughout the course of this Zoominar. You know, having to do with due process and how you actually can litigate cases during this time period and with the restrictions that we have during this time period. And so if we get our clients out and released, then it's our belief that they are going to be safer in terms of not being at as great of a risk to contract the coronavirus, that they're going to not have as many of the negative sort of collateral consequences of being detained during the time of the coronavirus, like the quarantines and limited restrictions and then also, you're not going to run up against the time periods and violation potentially of their rights to due process. If they're released, there's less of a concern on that front. So we're doing everything we can to try and get our juvenile clients who we represent at the Center for Juvenile Law and Policy out of detention because it improves their outcomes on all levels. Next slide, please, Maya. So I want to tell a story about one young woman who has gone through the system during the time of the coronavirus. Her real name is not Lola, but I'll call her Lola. She is 14 years old, and at the time that the coronavirus first was locking us all down, and when we saw the courts were initially closing and we were having our stay-at-home orders, Lola was inside of the juvenile hall. And she was inside of the juvenile hall at 14 years old with her only prior offense as a misdemeanor vandalism from 2 years prior. She has had trouble staying put and staying in one place and has had a history of leaving placements and of leaving her home. She was not our client up until there were previous lawyers who worked on her case, and we took over her case about a month and a half before the coronavirus hit. We got her pending case dismissed, and she only had this prior case from 2 years earlier, a misdemeanor vandalism, and she was waiting to go to a suitable placement. A suitable placement is a place where you send kids who otherwise would be doing well in the community, but there seem to be some issues going on with their home, with their parents may be limited in their ability to supervise the young person in a way that's going to promote their success. So unfortunately, kids are held in the juvenile hall awaiting one of these suitable placement beds. And Lola was sitting there in juvenile hall waiting for a suitable placement bed when all of a sudden they were on lockdown. She described just being out in the common area with other girls and being told they had 15 minutes to get into their cell. And then they were locked down immediately for 23 hours of the day. They weren't told they would get education, but they were not immediately given any education. At a later point in time, when they have been given education, these are things like packets that you do alone in your cell. So there's really limited educational opportunities, and that's a huge issue for all of the kids who are in juvenile hall. There also was an immediate lack of an ability to access any counseling, and there were restrictions on when you could communicate with your family. At a time like the coronavirus, when it's stressful and unknown, it's all the more important for kids to be able to communicate with people outside. We know that relationships with your family are the things that are going to promote someone's long-term success when they re-enter back into the community. And it became increasingly difficult to have communication with your family. And on the telephone, all of those lines are recorded. So it was really difficult there. Lola has, she did since get out into a suitable placement, and then wound up leaving her suitable placement and getting rearrested. What she got rearrested for was giving a false birth date to the police. She was a passenger in a car accident and was accused of giving the wrong birthday to the police, and they arrested her and they detained her. The prosecution then refiled the previously dismissed case and also filed this case on giving false information to the police. She did not have a warrant out for her for having left her suitable placement. So the only way that she would have been detained was if they arrested her, at the time of the car accident, when she was a passenger in the car accident. And I think that we can all agree that this is a particularly minor offense, giving the wrong birthday to a police officer, and the kind of thing that even before the coronavirus, we would not necessarily expect somebody would always be arrested for, detained for, and charged, particularly when you're 14 years old. So Lola is back again in juvenile hall, and we have set her cases for trial. While she's in juvenile hall, we'll talk a little bit more about what some of the issues and difficulties are in investigating, in litigating, and potentially going to trial. But I also want to talk for a moment about the other item on this slide, which is a probation officer's insights into what was going on inside the hall in terms of sanitation. I don't know if it's perhaps because I've done this for a while, but I wound up receiving a call from a probation officer who I knew, telling me that he was really concerned about the sanitation issues inside of the juvenile hall, and some of the issues with staff being redeployed to juvenile facilities despite not having proper training. And fortunately, I was able to hook him up with some others to pass along some of his concerns, but I wanted to share some of those with you right now. He was really concerned that inside of juvenile hall, they were not taking the adequate precautions with sanitation, right? That they were not wiping things down, that they didn't have enough wipes, that they weren't all wearing masks, and that the officers were segregating themselves far away from the kids, and that they were sometimes letting the kids congregate, right? So it seems like we kind of have these two extremes of kids either being totally locked down or being allowed to congregate, but with the officers farther away, and then being exposed to more danger and less supervision because perhaps the officers are concerned about being closer to the kids. And there's a big issue with staff training. The probation department runs our juvenile halls, they run our camps, and other than that, probation officers are the people who communicate with people when they're on the outside and doing well. So an adult probation officer has nothing to do with working inside inside of a facility. They manage and supervise the clients who they work with by meeting with them while they're in the community and trying to help them succeed in the community, holding them accountable in the community. They don't have experience working inside of a facility. And as you can well imagine, working inside of a facility with juveniles, you'd have to have particular training. Simple things like CPR. Other things like understanding more about the development of young people and how to communicate effectively. Other issues like how to de-escalate a problem between two kids, and how to basically work with kids. So this probation officer who contacted me was really concerned about these issues to do with sanitation and these issues to do with redeploying officers to juvenile halls who had no juvenile specific or facility specific training, and that posed as well a health concern and a safety concern. Maya, could we go to the next slide, please? So this is just about how we are advocating for the release of our clients, really in these two ways: the individual specific cases, and then CJLP has gotten involved in the larger issues as well, some of which Professor Kennedy will talk about. So in individual cases, we have filed motions to release our clients, and we have a lot of issues with any time we're trying to file motions or get onto calendar to be heard when our case isn't already set. So we made a huge push as the coronavirus was hitting to just advocate for each and every client who was detained for them to get out. And we also have been trying to negotiate with the DAs, but there's been no uniform policies in how they have been handling cases and what cases they are prioritizing. As the story of Lola's case shows you, even really low-level cases are being prosecuted at this point in time, and that's not necessarily in line with being progressive at this moment of the coronavirus. On the big picture side, we at the Center for Juvenile Law and Policy have been involved in statements that have been made by juvenile defender organizations. Professor Brooke Harris worked really hard with the Pacific Juvenile Defender Center to come up with a statement. That's linked on our website. The National Juvenile Defender Center, we worked with them on a statement as well. And also there is, again, all of these linked on our webpage, a document that I put together with Data for Progress and the Justice Collaborative, where we actually polled people in the United States to see if they were in support of juveniles being released due to the coronavirus and the conditions kids faced due to the coronavirus. And they were in support of kids being released, especially when they learned about some of the conditions that kids are subjected to. We've done a lot of work with reporters, and then Professor Kennedy has done heroes work filing a writ and working on behalf of all the kids who are detained. And so I know he's going to talk a little bit about that case in a moment. Maya, could you hit the next slide, please? So, in terms of talking about why it's so important for kids to be released, I want to say a word about trauma. And I want you to take just a moment and think to yourself, how common is trauma amongst kids in the juvenile justice system? Right? How common is it, do you think, that kids outside of the coronavirus, before this point in time, kids who are in the juvenile justice system have experienced some form of trauma? You all probably have a guess of how common it is. Maya, will you hit the next slide, please? So a pretty recent study of kids who were detained in an urban facility in Chicago showed that 93% of kids in the detention facility had experienced at least one traumatic experience in the past year, and more than half of those youths reported that the traumatic experience was witnessing an act of violence as the trauma. So that tells you about the population of kids who are detained, right? We're really interested in getting those kids out because these are the most vulnerable among us. They're the most traumatized even before everything that's happened with the coronavirus. Maya, next slide, please. And it's super important because kids during this time period of adolescence, which is generally 12 to the mid-20s, so also affects a lot of the young adults that are in the adult system, this is a tremendous opportunity for their brains to grow in both positive and negative ways. And if we are locking them down in ways that are really limited, then we are, as a society, all complicit in helping them to develop in a way that is not so positive, right? If we are depriving them and they are then being subjected to conditions that are more like solitary confinement, it has a really negative effect on them, not just in the moment, but on their brain development in the long term. And what we want to do is something more positive and less depriving, particularly when this is a collateral consequence of being detained that was not anticipated. Next slide, please. This pretty much says the same thing, but if this is a topic you're interested in about developmentally appropriate settings to promote growth and not deprive an individual and halt their growth, a great book is by a guy named Lawrence Steinberg. I have it over here on my shelf. I was going to maybe show you. A great book is by this gentleman, Lawrence Steinberg. It's called The Age of Opportunity. It talks a lot about this brain development and the intersection of juvenile justice. Next slide, please. Professor Kennedy, take it away with the California Supreme Court case.
Yes, so, working with Sam over the years has really hit home the importance of doing everything you can to get all of our young clients out of custody. And Sam mentioned Lola and being detained for kind of a low-level crime. I have to say most of my clients are teenage boys in foster care with guns. And a lot of the discussions of COVID-19 release, it's like violent, no. Violent offenders, no. Violent kids, no. But really, there are so many different ways to ensure safety while a case is pending that I think it's important to try to get out as many youth as you can, get them out of custody, given what we've heard. So the Center for Juvenile Law and Policy, as well as our independent juvenile defense panel, got together and represented pro bono by Patricia Song, our former staff attorney at the center, who now works for Children's Defense Fund, filed a mandamus petition invoking public interest standing on behalf of all detained kids in LA County. That's all the juvenile halls and all the camps out there. And the theory was that Sheriff Villanueva, who I think of as a pretty tough sheriff in a lot of ways, had been collaborating extensively with the adult court, the DA, the public defender, the alternate public defender, what they often refer to as their justice partners, to radically reduce the population of the jails. And it's not enough, but he had done a lot of reductions. Thousands of people have been released from Men's Central Jail and other adult facilities, but there was much less collaboration going on the juvenile side. I'm not going to say there was none, because there have been some meetings, but it just wasn't happening on the extent it was on the adult side. So our theory in the mandamus was that it violated all the kids' right to due process for the juvenile court to sit and do nothing and not frame some kind of a process where as many detained kids could be released as possible to ensure their safety. And as Sam mentioned, we also talked about a lot of the difficulties of complying with the CDC guidelines for COVID-19 in a custodial setting. It's very difficult to enforce social distancing. And in fact, like one of the reasons the sheriff did it is the bunks are not 6 feet apart. And they were trying to put head to toe so they could say, well, we can have you close if someone's head is next to your toes. And the CDC was not big on that. So the theory was that the court needed to do more to release juveniles in a systemic manner, focusing on medical factors and forensic factors. Medical factors are obviously medically vulnerable persons in custody. And probation, I think, has always taken the position, even now, I believe, that there are no medically vulnerable kids in juvenile hall. I know that's not true because I have a client with asthma, and the CDC lists asthma as an example of medical vulnerability. And then forensic factors, people who have, very little left on their sentence, people who have minor crimes. And so the lawsuit alleged a due process violation on behalf of all the kids because of the systemic failure to do anything to ensure the health and safety of detained kids in our juvenile halls and camps. The Cal Supremes unanimously issued an order to show cause, focusing on whether we were taking efforts to ensure the safety of those who were detained. And it was sent back to the California Court of Appeal, Second District, our district, to hold the hearing. They originally assigned it to the supervising judge of delinquency court, which we thought was problematic because it was the delinquency court that we were alleging had engaged in the due process violations. So it was transferred to a dependency judge who did hold a hearing, but he did not allow us to do any discovery or call any witnesses. And he denied the mandamus for failure to prove our case. Now, obviously I'm involved, but I think it is pretty difficult to prove your case when you aren't given discovery and witness testimony, live witness testimony in court. So we are appealing that. But I will say this, Sam, I think just the filing of the petition, while we have not been successful to date, really created a push to do more to attend to these issues. And we've seen, the COVID-19 update that probation is putting out is much more transparent than anything we were seeing before. And I think the efforts have been stepped up. I used to talk to clients who said no one was wearing any masks in Sylmar. And when I talk to my clients now, they do talk about some efforts to follow some of the CDC guidelines, although the fact remains that at this mandamus hearing, probation's lawyer took the position that first, no court can supervise them in regards to the custody of juveniles, that the court has no ability to supervise them. They didn't say who does have that ability. And that they are not required to follow the CDC guidelines for COVID-19 or the Department of Public Health guidelines, the state guidelines, either, because organizations running custodial facilities aren't subject to it. Now, I'm not sure where that comes from.
Outlandish, right?
Well, I respectfully disagree, Sam. And I'm not.
I'll say
sure,
it's outlandish.
I'm not sure where it even comes from. And I do want to add, in fairness, that probation recently held its own town hall, and it pledged to try to follow the guidelines, although it made clear that it believes the guidelines make exceptions for custodial facilities. So I'm not sure there's a change there. And then finally, and this is disheartening, probation's lawyer argued that anything short of deliberate indifference to human life was not even cognizable on mandamus. And, the idea that short of murder, you can do nothing to vindicate the rights of detained youth who are at risk for infection in there is a pretty discouraging and I think startling proposition. And I also disagree with that as well. We'll see what the appellate courts say.
Yeah. Professor Kennedy, before we move on, I know there was a question in the chat about whether or not there are options other than detention for young people in the juvenile system. And part of what this suit was fighting for, part of what we're trying to do on an individual level, right, is release kids from detention. And I think for all of the non-criminal justice practicing lawyers who are a part of our group today, we might just take a minute to talk about what some of the other options are that exist for kids in the community. So one of the things that can happen that's sort of at the higher end of restriction is a kid can be placed on an ankle monitor that is monitored through their home. So it's called the community detention program, and they can be released to their home, but then they can't leave their home. So that's one way that they could be released back into the community, but still the court and community could be assured of safety. And one of the things I know I've said to a few of my clients who've been on the community detention program is, hey, we're kind of all on the community detention program because we're locked down. None of us can really go anywhere else. So the thing that's hard is that, if you're off of community detention, you are stuck at home, but you could go for a walk in your neighborhood. And the kids who are on the community detention program often can't even do that. So they used to be able to go to school and then come home, and now they are just stuck in their house 24 hours a day, and that's really rough. There are some other options in the community, and kids can be released with various levels of supervision and support that don't. So there are a lot of alternatives between detention and like absolutely nothing, running free. But that's just one option, the community detention program. Professor Kennedy, I don't know if you wanted to say any more about that.
Sam, we had a question from one of our colleagues at Cerritos Community College. Well, happy to have you here. Why is there an ability to sue probation for like civil rights violation the way that we hear the ACLU doing maybe with the sheriff's department or adults facilities? And why aren't there more lawsuits? Any thoughts on that?
Oof. Well, for one, it's hard. I think there are a lot of organizations that are trying to collaborate and work together. But at this point, I'm finding it really hard to just gather the data and information that we would need, right? Probation's kind of in control of a lot of that data. So it could be that, this will be coming down the pike. And that organizations like the ACLU will do it. I know that a lot of organizations, ours included, have been getting together and trying to talk the people who are on the ground, seeing work with clients, with the people who are doing, the larger civil rights issues, to talk and identify what some of the issues are. But those cases often take a very long time to build, and there's a lot of challenges just to basic litigation and discovery and investigation at this point, given the coronavirus and how difficult that makes things. I think those are things we'll see down the line, but they'll probably be related to damages, and it's a lot harder, I think, to amass those kinds of lawsuits at this moment.
Yes, I'll say this, our lawsuit, our mandamus, we weren't asking for money, and right. Still the clause came out. So it's a real endeavor to sue them. I do believe there are organizations such as the ACLU who have tried, but many young people in detention are in the foster care system. There's just not a lot of people looking out for detained kids, which is why I'm so proud of this organization and this Zoomazar, whatever it's called. And then I just want to say, Peter, like I've been making California Public Act records request about the failure to get together to try to attend to releasing more youth. And the response from the court, the delinquency court, which is supposed to be watching over them, is that we're not answering any of those during the pandemic. The court is closed only for essential business, so we're not answering your Public Records Act request. And I suspect that civil rights lawyers are experiencing the same thing.
Right. I saw another question that came up in the chat about racial disparity, and that question is spot on. I also wanted to highlight that at the end of our presentation, you'll also see our statement at the Center for Juvenile Law and Policy in solidarity with the Black Lives Matter movement. And absolutely, it is the case that at every stage of the juvenile justice system, the kids who are the most likely to be arrested, the kids who are the most likely to be detained upon arrest, the kids who are most likely to have charges filed against them, the kids who are most likely to be transferred to adult court from juvenile court, and the kids who are most likely to be sent or sentenced or dispositioned, as we call it in juvenile court, to a facility of some form of incarceration are kids of color at absolutely every stage. And the same is true of kids who have disciplinary issues in school that then wind up in the juvenile justice system. The statistic there is 1 in 3 of the kids who are expelled from school and kids who are charged in juvenile court for school-based behavior, 1 in 3 are an African-American man, African-American young man, and that mirrors the stats in the adult court system. So while I can't give you the specifics of coronavirus-related detention, I have every expectation that it is exactly the same as it is in every other aspect of the criminal and juvenile justice system, that kids of color are the ones who bear the brunt of being in detention and more and most of being charged more for similar behavior, and that they are then at greater risk for this isolation and also at greater risk for contracting the coronavirus, at greater risk of reduced opportunities to due process during the course of their cases.
Want to go to the next slide?
Yeah, let's go on the next slide. So, I mean, there certainly are some hopes that we have long-term for some structural change. I hope, I think we all hope that as a result of seeing that more people are being released, we may in the future be able to look towards drastically reducing the number of kids who have to be detained. If we're advocating for youth to be released during this time period, and those youth are released during this time period, we may as a society see proof of our over-incarceration, right? The United States incarcerates more people than any other place on earth. That's true of kids, it's true of adults. And it would be a great hope that as a result of what's happened here and what continues to happen, that we realize as a society we don't need to detain the number of people we've been detaining. Hopefully we'll also learn that juvenile offending and recidivism are not increasing the more we release kids, right? So hopefully that's something that we'll see. These are our ambitions and hopes and beliefs. Hopefully we will also improve our readiness to respond to a crisis. There have been a lot of crises. We've had the fires as a crisis, right? And you have probably all seen some of the problems with the way the probation department handled the fires and how they did not have appropriate emergency protocols in place for that. So we just need more emergency readiness within all of our systems, court and the detention systems. Hopefully we can improve sanitation, because anyone who's ever been to a criminal or a juvenile court, a criminal or a juvenile jail, or juvenile hall, or a juvenile camp will know that these are some of, in the best of times, some of the dirtiest places you ever have been. And hopefully this will improve the sanitation in those, in all of those places for the people who are forced to go through that system. And hopefully we will see improved access to visits with family and with education through the use of online resources. Hopefully we see this as an opportunity to bring some computers into the juvenile halls and into the jails in a way that provide greater access to the outside rather than reduced access to the outside. Although I am concerned here, and I will say about this, after Katrina hit New Orleans was forced to do a lot of the things that we are doing today. They were forced to bring videos in and have video visits with family members. And just as a tragic example of what's happened there, kids who are charged as adults, waiting for trial as adults, have had the opposite. Instead of improving access to their family and being able to see them more because they could see them over video or see them in person, they've actually eliminated in-person visits currently, right now in New Orleans, and this is a side effect of Katrina and bringing the videos in. They've eliminated in-person visits for young people charged as adults while they are awaiting trial, and they can sit there and wait for trial for a year and a half. So my hope, our hope, right, is that we improve and have greater access and more ability to see family while individuals are detained. But the fear is the opposite end, right? That we replace in-person visits with just video and video alone. Next slide. Yeah. Professor Kennedy, do you want to say a little bit about this?
Yes, and we're getting questions about, what will trials look like. So Sam has stated kind of some of the big picture goals, but we're both former public defenders. Sam, PDS, myself, federal public defender. And one of the things that, really always troubled me when I was federal defender is, hey, is this place following the ABA guidelines for the defense function? And every few years, I would look at them, and I felt like the answer was, not yet. Not yet. And so I want to remind defense counsel on the line that although the pandemic has raised incredible challenges, and the courts and probation have, I believe, really tried their best to meet them, if they don't meet due process and the standards for high quality, effective representation, the duty is on us to bring that up. And so it has to be on our radar. So I just want to talk about remote client visits. It is very hard to get into juvenile hall. And even if you can get in, there are a lot of concerns about getting in. And so a lot of us are checking in with our clients by phone. Sam, are you doing this?
Absolutely. And first question, right? I try and get probation officers on the line every single time and say, is this phone call being recorded? Is this a recorded line? Nobody will give me a straight answer, so we have to assume it is.
Amen. And I also know it's not confidential because my clients often won't talk to me about parts of their case because they say, I can't talk about it. There are too many people around here. Also, in this day and age, a lot of the discovery is surveillance camera footage or photos or CDs. And how do you review that over the phone with your young client? And so, I just have real questions. The ABA guideline for having confidential visits is 4-2.2, and it says that custody facilities and courts have to have places where defense counsel can have private, confidential communications with the client. I don't think we're meeting that. I don't think that's going on when I'm chatting with my client on the phone. Should we move on to the next slide?
Great.
Yeah. Sam, you want to talk about this one?
It's a nightmare. Sure. One of the people on this webinar was actually texted this morning by our certified law student for the summer saying, hey, are you there in Compton? Can we maybe send you a motion to file? Could you print it out and file it for us in court? Because we are looking for creative ways to physically file motions. Even though most hearings are taking place over WebEx, which is essentially like Zoom, they're saying we have to come to court to pick up probation reports. Some clerks will email it to you, but not most. And you've got to actually go in person to file a motion. Some of this is absolutely flabbergasting because we should have been able to receive probation reports, discovery. We should have been able to file motions and receive motions all over the internet 10, 15 years ago. Like, there's no reason, particularly in the time of COVID, that this really has to be happening, but it is an absolute mess. One of the courthouses has a box outside where, you go and you just drop your motion in the box. It just seems really, really silly that we can't be emailing this as proper service. And one of the other kinds of processes here, I don't know, Professor Kennedy, have you had an experience trying to get an expert to evaluate a client during this point in time?
It's just impossible to get anything. Yesterday, I had a student picking up supplemental discovery, and he wasn't allowed to go into the DA's office in the courthouse. The sheriff stopped him. And I said, no, we got to get it. And, he kept calling and finally worked it out. But it is strange that we have electronic court hearings, but we have no ability to electronically file motions or even receive the probation reports electronically before you go to your electronic hearing. So what does that mean, Sam? Are we doing hearings without access to the documents?
Absolutely. I have.
I am.
We had when our young client who I called Lola, when she was arrested and she had her new detention hearing, we asked for the detention report from probation to be sent to us. We did the hearing without the report. Fortunately, we've been representing her for a while, so we know things, and that is helpful. But it's really hard because you're operating with your hand tied behind your back, and that's not fair to the kids, and it's not fair process.
We're getting questions like, how is it consistent with attorney-client privilege that they don't tell you if it's recorded? Well, I think the lawyer needs to do something about it. I think we need to bring that up with the court and litigate that. And then a very practical question from one of our former students, now a public defender, about, sometimes the experts are afraid to go and see the client because of the health concerns. And, to me, to me, that is in and of itself a reason to relitigate detention.
Right.
If you can't, there's a due process right to experts, and if you can't get experts to go see the client, maybe we should reevaluate detention.
Right, exactly. Mike, could we have the next slide? Which brings us to another issue for how to also revisit detention. What kind of luck are you having investigating, Professor Kennedy?
I just feel like I'm airing all of my flaws as an advocate. I just really wonder how much investigation is going on out there. There are shelter-in-place orders, safer-at-home orders, and we know that law enforcement are exempt, but at least in the beginning, it was less clear whether lawyers, law clerks, defense investigators are exempt. We clarified with Governor Newsom's Justice deputy that he meant for people who are rendering legal services to vulnerable populations during the pandemic to be exempt, but institutions that we all work for and respond to don't necessarily know that. So, I think we have to take stock because, again, the ABA guidelines for the defense function impose upon us a duty to investigate the facts of the case to see whether there's a factual basis for the criminal charges before we do anything. And you're not allowed to give it up, even if the client, says certain things to you. So I don't think that there's a global pandemic excuses it, but it makes it hard. And so, some of the compromises I've engaged in are telephonic interviews that in the past, I would have said that's not a good practice. You ought not to do that. I have done it. And then the other thing is, I've been supervising some live investigation, but it's hard because the law clerks or investigators doing that, I ask them to make sure they protect everyone, including themselves. And you need to be in a mask and you need to be 6 feet away. But Sam, how do you have hard conversations about sensitive matters when you're yelling at someone through a mask 6 feet away?
It's really difficult. And, you might freak them out. They may be like, no, just the fact that you're here, I find offensive, and now I don't want to communicate with you. And so it's really, really challenging to investigate cases at this moment in time, and in some instances impossible. So to your point earlier, Professor Kennedy, how does that relate back to detention advocacy?
I really think we need to, because we're all socialized about this won't work, this is in play, this won't work, crime of violence won't work, too much of a history. I really think we ought to give that a second look nowadays, because if you cannot meet the basic guidelines for high quality of effective representation, then it could be solved by taking the client out of custody, trying to remove as many contacts with probation and problems that you can, and continuing it until we're at a place where you can. And I have a client with asthma in an armed robbery. I thought I can't do it, but I did a detention hearing. I got creamed. I went back. I hired a pediatric pulmonologist to talk about the dangers of asthma. And I talked about some of the dangers of the problems of representing someone in custody at this time. And now he's on an ankle bracelet. So yeah. I think that even if in the past we'd say this one is not worth it, because there are so many impediments to representing our young clients, we should just keep pushing for release.
Exactly. Maya, next slide, please. Okay, so now this is a super fun one. Issues with WebEx. WebEx is really difficult. I think we've all experienced hearings where we're seeing people, and sometimes, there's not as good of a visual. I have had WebEx hearings where this is my view of the judge. I've had WebEx hearings where my client's not present because they're actually released and in the community. And so they're like, yeah, no, we don't need the client to have this hearing when it's their hearing. I nearly burst into tears, and I held them back when, for the very first time, I saw my detained client sitting there with a mask, with probation officers, standing there behind her in a closed room, and her, sad stance as she sat there, trying to have a kid be able to understand what's happening when they're in one room being guarded. You as their attorney are in a totally different place, and then the judge is there masked, and maybe you're seeing the back of their head, maybe you're seeing the side of their head. I had another hearing today where the judge was like looking down at the ground, and so you can't see a facial expression or understand people as well, through a mask, and it's really, really challenging. I'm concerned about my client's ability to understand what's going on, and I'm concerned about a whole bunch of things. Professor Kennedy, what are you concerned about?
Yeah, I'm beyond concerned, because I have done WebEx hearings with clients in custody who I have called on the phone afterward because I actually couldn't talk to them privately during their own hearing, because when we speak, everyone else on the WebEx would hear, and they've told me they didn't hear anything. And I'm like, why didn't you say something? And, teenagers, being teenagers, they've told me, look, I was embarrassed. I didn't feel comfortable saying that I couldn't hear anything at all. And so That's a concern. And then I have a concern about myself and my quality as an advocate, because while I'm on WebEx, um, they are referring to, and the prosecutor often is in the courtroom
Mm-hmm.
with the judge, and they're referring to a report that won't be given to me. I've asked, and it won't be given to me.
Yeah.
You have to come down and get it, but it isn't prepared until like right before the hearing. So you can get it, but you get it after the hearing. And I've done that and done a motion for reconsideration. But the ABA guidelines say straight out, 4-4.6, that we have a duty to be prepared for court proceedings. And my question is, how can I be prepared for a detention hearing when I don't have the report or whatever? And you can put things over, but the client often doesn't want to put it over. And so there are real conundrums with the virtual hearings that are going on.
Absolutely. Next slide, Maya. So then there's issues with in-person hearings. So obviously sanitation practices are a big concern. I've had hearings where judges are wearing their masks over WebEx. I've also had hearings where judges are not wearing their masks over WebEx, which means that they are then contaminating the courtroom. And the courtrooms, as we all know, are crowded and small spaces. They have a lot of different surfaces, and while the coronavirus does not live on surfaces forever, it does live there for a couple of days, and so that is a concern. We had the problem in West Covina. I hate to say problem because it's a real tragedy, where a public defender died, and there were 8 others who had, at the time of the reporting of the Los Angeles Times article just last week reporting the death of that public defender, there were 8 others who had been infected and tested positive at the same time. Unknown how many people were tested, but at least 8 who had tested positive. And obviously we know something my dad said to me at the early stages of the coronavirus: the problem with it is it's just so darn contagious. Exactly. So if we have inadequate or inconsistent practices that are going on in the courtrooms, if there's nobody really monitoring whether everyone's wearing a mask at all times, which granted is annoying. In many ways, I'd rather communicate over Zoom and have you see my face than I would rather communicate in person with a mask. I would be concerned about the sanitation in the courtrooms, exposing my clients to those environments. I'm concerned about exposing myself to those environments. I'm concerned about, as a clinical professor, exposing my students to those environments and exposing my client's family. I also am concerned, one of the things you see here about confidentiality and ethics, at what point do we have, we're required as defense counsel to protect our clients' confidences. What if there's something we know about the coronavirus and an exposure our client has had, but they nonetheless want to have their right to confrontation? What steps are being taken to make sure that without attorneys being put in a position where they're being challenged with disclosing private and confidential information, what's being done to make sure that the people who actually go into the courtroom and go into the courthouse are not positive with the coronavirus? It doesn't appear that they're testing people day in and day out going into the courthouse. And so there are some measures, but they're clearly not enough. And one of the things that keeps me up worried at night, and no matter when we go back, are the elevators in some of these courthouses, which seem to be the exclusive way to get up and down, are small, confined spaces with recirculated air. And I don't think you could have more than one person in the elevator at a time without violating the CDC guidelines. And then, Professor Kennedy, do you want to talk about masks in the courtroom and maybe other protective gear, like what if we're going to court and we're in full, PPE, how that's going to affect your ability to constitutionally
Yeah.
try a case?
I really think that this is an area where only defense counsel has the incentive to ask the hard questions, because as Sam talks about it, I realize that this is where the court and probation's problems with following the CDC guidelines intersect. Because I want live trials, but while I'm criticizing respectfully our colleagues in probation for opting out of the guidelines, I think the guidelines require masks and distancing. So what are you going to cross-examine someone in a mask? And does that meet the right to confront and cross-examine witnesses? I have real reservations about whether it does. And the option of Zoom or WebEx or whatever allows you to see the face. But, I have real reservations about that. There have been 2 death sentences handed down via Zoom already, not in this country, although I understand Texas is really pushing for Zoom everything. And so, these questions about how to deal with the constitutional problems that collide with the safeguards required during the pandemic deserve to be vetted and raised. And it reminds me, Sam, I was a public defender during the big federal sequester when the federal government went broke. But of course, the prosecutions kept going on, and I had no money for experts and travel. And the court would say, "What do you want me to do? I don't have any statutory authority to give the federal public defender more money. So what do you want me to do?" And my response was, "Okay, I guess under the law you can't, but you can dismiss the indictment because we cannot meet the constitutional requirements for prosecuting people and convicting and imprisoning them." And there is case law out there in the Federal Reporter where when you can't do it consistent with constitutional requirements, you must dismiss, even in something as pedestrian as the sequester. I would think that we are the people who will make the case law resolving the balancing of the need to protect everyone from the pandemic versus the ability to conduct a constitutional trial. But it will not happen unless we litigate those things. And Sam, I experience enormous pressure on WebEx from judges to be reasonable. It's like a new world. It's a pandemic. What do you do when everyone is leaning on you like, come on, are you really going to take that position now?
It's tough, right? Because our clients have rights, and their rights don't go away because of a public health crisis. And so,
amen. I want to high five you, Sam.
High five. Even before the coronavirus hit, I had another situation where it was the first time anything like this had happened to me. I had a client who had a contagious illness, and the probation department was refusing to bring that client to court for a detention hearing. And we said, that's fine, but you've got to release the client, right? They can't, if they don't want to transport the client to court. Well, it turned out then they transported the client to court for their hearing, and took the adequate, safety precautions necessary to do it. But if you don't insist on it, you're never going to have the rights respected. And in my experience so far, even if you are insisting on it, it's still hard.
That's where the battle does not, the trial court is not the end all and be all. I think we also need to start going to the appellate courts, even if that's not stuff we normally do. We're, running. We've run out of our time, so maybe we should.
Yeah, so we should stop and let people go, or see if anybody wants to stick around for a minute or two with questions. This is our statement from the Center for Juvenile Law and Policy in support of the Black Lives Matter movement. I'll just read it. The Center for Juvenile Law and Policy at Loyola Law School continues to work in solidarity with our Black students and clients, especially those who stand up to be heard in protest. Black people, particularly Black children, have too long been forced to sit outside the doors of justice, waiting to be let in. Those doors are now splintering and breaking, and the keys of the law are lying unnoticed nearby. Just unlock the doors. Thank you.
Thank you. So I guess we should conclude, huh?
I think so.
I just want to invite anyone on the line to call or email us, Sam, about any problems. I don't know that I can answer it, but there's a bunch of great minds at the Center for Juvenile Law and Policy and really our bigger Loyola Social Justice Clinic that will try to help you. You're not alone when you're tackling all of these problems raised by the pandemic, but I think we are the only ones who will bring them up and fight them, and you never know what's going to happen. I certainly didn't think we would get public interest standing to litigate on behalf of all detained youth in LA County, and we did with a unanimous Supreme Court opinion. So you might be surprised by good things that happen when you litigate.
Amen. Thank you all.
Okay.